CCJ Appeal number CR2 of 2006 and CCJ Application number AL5 of 2006 between Dennis Maynard and the Queen.
Yes.
Please, Honorable Court, I am Maynard Silver. With me is my little friend, Ms. Caroline Best. We appear in association with our learned friend, Mrs. Angela Bishop Giddens. We appear in the appellate application this month.
No one appears for the state, no? No? Yes. Yes, well, Mr. Pilgrim.
I just like to apologize first for the absence of Mrs. Giddens. She is pregnant as well.
That's all right.
If it pleases this honorable court, we propose to address on the notice of application for leave to withdraw notice first.
Yes, you are seeking leave to withdraw an appeal which was wrongly filed without a special leave by this court.
Indeed, Your Honor.
Yeah, well, that leave is granted, Mr. Pilgrim.
Grateful to the court. We pass then to the second matter, which is the application for leave to file out of time, Your Honor.
Yes.
As the court will be aware, the application is predicated by the fact that the initial application was entirely erroneous. We apologize to the court for that, and we have sought from the moment we were aware of the error to put that error right. The circumstances, I think the court has it from the notice to withdraw, are that the applicant appellant filed a leave from the local court of appeal. It was done in good time under the wrong rules, and that was later confirmed.
Well, it's not so much under the wrong rule, but there is no power in the Court of Appeal
Indeed.
to grant leave, and that is under the Act.
Indeed, Your Honor.
And, it's unfortunate that you didn't read the Act.
It's most unfortunate. Your Honor, I think that there's a certain amount of fear that surrounded this court. And we thought, that we should get advice. And for reasons that can hardly be apologized for, it was thought advice was better than reading. And it is something for which I can hardly apologize for enough. But we were able then, in that whole melee, to mislead a court through the failure to read, and apparently to mislead the Crown as well. So that all of us were reveling in the mistake for some time. So at this stage, sir, all we can do really is apologize and ask the court to take into account the fact that we were trying to take the steps to appeal from the outset, and We would also like the court to take account of the fact that the Crown was apparently showing no objection to the substance of the appeal throughout that process.
Well, I'm not sure what you mean by showing no objection to the substance of the appeal. What does that mean?
Beg your pardon, Your Honor. What I should say is that when we appeared and asked the local court of appeal, however erroneously for leave, their position was that they did not object to that application.
They did not take the point that the Court of Appeal had no jurisdiction.
They didn't take that point, Your Honor, and they also consented to the application. So they didn't seek to oppose the leave that we were seeking.
But, Mr. Pilgrim, there is a case called Brent Griffith and the Guyana Revenue Authority, which was a case from Guyana based on similar legislation, where we had explained that special leave had to be obtained in criminal matters from this court. That decision was given on the 12th of May, 2006, and would have appeared on the website at about that time. So that prior to your getting final leave on the 24th of May,
It was 24th of March.
was it March? When did you get final leave? The order seems to be saying the 12th of May, but some of the papers would say that March 24th.
24th of March, I believe. Yeah.
You see, I have an order here which says 24th of May.
The affidavit says the 24th. The affidavit says the 24th. I haven't seen the orders yet.
The order is in the earlier the application to withdraw. You said that before the Honorable Sir David Simmons on the 24th of May 2006, and then it was entered on the 12th of June 2006.
I think that is correct, sir.
So I took it to be that
24th of May.
date was the 24th of May. That's what it says in the order.
That is correct, sir.
But you see, the result is that it's over a year now since the Court of Appeal gave its decision.
That's correct.
Tell me something which disturbs me somewhat is that the Court of Appeal reserved its decision for 4 years.
Correct, sir.
Does that happen often or in Barbados?
Your Honor, what I would say is that
Beg your pardon?
what I would say, sir, is that that has ceased to happen under the present regime. Under the present Chief Justice, that no longer happens. There was a hiatus, if I could call it that, sir, between the time when His Lordship, Mr. Justice Dennis Williams, Chief Justice Williams went home. There's a period in between during which things fell very badly into disarray.
What, a hiatus of 4 years?
Your Honor, it was
When there was no Chief Justice?
I don't know if it was as long as 4 years. I don't want to say it was. There was a period during which neither of those two gentlemen were sitting. And there was an acting Chief Justice in that period. During that period, there were at least 5 matters in which I was involved, which took 4 years in one case, 5 years in another, 6 years in another, to be decided upon. There was a period during which we would write to the registry of the Court of Appeal asking what was the position with the decision. We were told we would get it soon. Indeed, this matter and some of those matters only came to light after bail applications were done on behalf of the applicants. So in the case of Dennis Maynard, he applied for bail, and the present Chief Justice sat in that bail application and said, if you come back to me for bail by X date and there is no decision, I will release the man on bail because it is too long for the decision and so on. But there was a period there where this...
But the other cases of your own that you referred to, there was a criminal or civil or both?
Criminal, Your Honor.
All criminal?
All criminal. I only dealt with criminal. One of them was even a capital matter, so that the condemned men were in this position of not knowing what their fate was, I think, for nearly 6 years. And
you see, if a court of appeal gives a judgment 4 years after the hearing in a criminal matter in which the appellant is in jail, they're going to find it acutely embarrassing to uphold his appeal and release him.
absolutely.
After having languished in jail for 4 years.
I agree with Your Honor, and as much as to give that decision then would be to embarrass the court. You're saying that, for example, we should release this man based on the strength of these grounds, and the man has been in prison for 6 years. In the capital matter, it was even more poignant because they had a choice. The court would have had a choice of a manslaughter verdict, condemning the man to hang, or releasing him. But having kept the two men for 6 years, we knew before we went for our decision, the only decision they could give was manslaughter. It was just a question of quantum, so to speak. They had to determine whether they would give him 6 years, which would be the exact period that he had languished, or whether they would give him more. In the end, they gave him more. But it was a very unfortunate situation. But what I can say with confidence is that the present Chief Justice has attempted to rein all of that in, and under his regime, there has been a very different and much more fluent processing of matters.
That does not surprise me, knowing the present Chief Justice, but I am still relieved to have confirmation that this sort of delay between hearing and judgment no longer occurs. Was on the civil side, we dealt with a civil matter. What was really in the nature of an interlocutory application, where I think the first instance judge took 4 years and the Court of Appeal took 5.
I'm aware very much of that matter.
Well, this is
hopefully these matters are now behind. I would consider them a dark period in the judicial history of our country, the legal history of our country, and hopefully with the advent of things as they are now, all of that will be behind us.
Yes, you see, we are a new court, and so we are new, among other things, to the Barbados jurisdiction, and we don't want to go in with a heavy hand, as it were. But this is a type of situation about which a final court would have at some stage to express itself in fairly strong language. Something which, as I've said, we have sought to avoid doing up to now.
So all I can really say in that regard is that my view, which I hope is an educated one, is that the current Chief Justice has resolved these problems. And that he is, certainly with capital matters, there is definitely a much more speedy situation. And generally, I think it is safe to say, I can only speak for crime, I only appear in criminal matters. But in respect to the criminal matters, they are being expedited. And we would consider 3 months now to be a slightly long period for decisions. So generally, I can say with confidence that between 3 and 6 months, the decisions, certainly the ones on which the Chief Justice is sitting, will definitely come within 3. where he is not sitting, maybe not quite as swift as that, but certainly within what I would consider a reasonable time, and certainly by comparison, a very reasonable time.
Yes, well, I mean, you see, the appeal here in this case to the Court of Appeal was heard of, but pretty promptly. It was heard of within a year
Yes.
of the conviction and the sentence.
Was
But
just
having
that-
been heard, then there's a lapse of 4 years while the court makes up its mind. Yes. Well, you are applying for an extension of time to file the application for special leave. And the need for that has arisen out of what was initially, what was really your error,
Yes.
but in which was compounded in a sense by the failure of anyone else involved to notice the absence of jurisdiction in the Court of Appeal.
Yes, sir. We, however, take full responsibility.
Yeah. No. And then I think if we well, this is very early in the life of the court, and it is the legislation was fairly recent at the time when the error was made. Still, there really is no excuse for the error, as there is no ambiguity in the provisions of the Act. However, in the circumstances, we will grant you an extension of time up to today for filing your application for special leave to this court. And obviously, this is not the sort of indulgence that we will grant to those who do not inform themselves of the provisions of this very important act in the future. And I do hope that the occasion doesn't again present itself where we are being asked to excuse a failure to read that act, because as I have said, we will be less indulgent after this.
Stand guided, Your Honor, and we're grateful to the court.
Yes, so the leave is granted, and you may proceed to argue the application for leave.
You may proceed to argue the application for leave.
My lords, Your Honor, the court would have before it the grounds which were filed in respect of this matter in the supplemental affidavit sworn by My learned friend is best. Those grounds are listed A through G. They take notice as well. I think notice of the application. One of the circumstances surrounding this matter that the felon was charged with trafficking in drugs, importation of drugs, and possession of drugs. A quantity of 509.61 kilograms. The applicant was then convicted of all three offences and sentenced to 25 years for the importation, 20 years for the possession, and 20 years for the trafficking. It was on the 29th of November 2000.
Was it not 25 years for the trafficking?
I mean, the trafficking or the importation? Double checking the back of the yellows. I crave indulgence, John.
What's that?
I crave indulgence just to verify. The 25 typically would be for the trafficking,
Yes.
but the note here says importation, so I just want to clarify that.
Yeah, I'm just looking at the judgment. It's in the
And the Court of Appeal quashed the conviction for possession.
Yes.
So that sentence was quashed.
Yes, so all that remains is trafficking, importation, and the
Importing and trafficking.
yes.
Not that it has any practical effect. So far as the appellant is concerned, it doesn't make any difference really to him.
No, sir.
He
has to challenge his 25 really.
25 years.
Joy out of the field. In practice in Barbados, my lords, once you have over 15 gram limit in the act, you will be charged typically with 4. They usually charge possession, supply, importation, and trafficking. If it's alleged that it's coming into the island, as was the allegation in the situation.
Well, the quantity here was a little more than 15 grams.
Just quite a bit over that.
Yeah, about 2,000 and something pounds.
It's about 1,000 pounds, I think, is the allegation.
Sorry?
only one?
1,000 pounds is the matter of the
Oh, I thought it went to 2,000.
I thought it was over 2,000, but anyway.
No, so it would be 509 kilograms.
2.2.
Yes, you could.
2.2 tons, I think, about 11 something or 12 something.
Yes.
Can't recall the exact amount, but
Yes.
1,200.
Yes, I see. Okay.
So the challenge that is made to the quality of the conviction is largely surrounding the identification evidence. if I could just give a little bit of background to put the court in the know as to the circumstances of the matter. This is a situation in which a boatload of marijuana in various bales was brought to the island on a speedboat. That's not in dispute at all as far as the defendant is concerned. The speedboat landed in an area of Barbados on the east coast, which is quite rough, known as Concept Bay. Similar, you can imagine, in terms of its topography to somewhere like Blanchisseuse, somewhere in that area. A number of men came ashore from that boat, and a truck met that boat in the area, apparently with the purpose, or obviously with the purpose of offloading bales to the truck for their later distribution or whatever the case may be. Police were there waiting, and there was a shootout between police officers and the persons present, and the police evidence has always been that they saw the appellant there. They, however, didn't arrest him there. They arrested several men on the scene and shot and killed a man on the scene, but the appellant was never arrested on the scene, and some weeks after he was later arrested at the Grantley Adams International Airport. And he has always maintained that he was not there. Not there on that night at all, had nothing to do with it, has always been his defense. The first ground listed as A. malus is that the Barbados Court of Appeal erred in law in failing to recognize that the learned trial judge had failed to properly direct the jury in relation to how they should approach the evidence of identification, and more particularly, misdirected the jury on the issue of special circumstances and indeed what evidence should be characterized as such when deliberating on such evidence.
It's not a fundamental matter, but I think I would suggest, as a matter of style, that it would be better in the grounds to attack the summing up directly rather than via the decision of the Court of Appeal. And of course, in arguing each ground, you would have to deal with the judgment of the Court of Appeal with regard to that point.
Yes.
But I think it's a little tortuous to have to frame it in this way.
Yes. Perhaps a more simplistic learned trial judge erred as follows, etc. would be more useful to the court.
Yes, you go ahead.
So that complaint is essentially, if the court can join me in the record, page 527.
Yeah. Okay, thank you. Yes, you go ahead.
So just to pick up on that line 22 of page 527.
Yes.
Now come next, Mr. Foreman, members, to identification. Identification may think is a matter of considerable importance in this case, and I must give you certain warnings in relation to identification evidence. Identification, which includes recognition as they put in evidence in relation to accused Maynard. You should approach this matter with particular care. I make a distinction between recognition
Yeah.
bring it back. It's like a reading. I make a distinction between recognition or identification by a virtual complainant who made a complaint to the police and is afterwards asked to test that identification, or recognition by identifying a person in the police lineup. The distinction here in this particular case is there has been no ID parade, but there are circumstances you may think, and I refer to the Evidence Act, where you may think that a lineup would...
Just a
Sorry,
minute.
sir.
Makes sense. Yes, you go ahead. Sorry, Mr. Pilgrim, to interrupt you, but you carry on.
Thank you, sir. You may think that a lineup would be pointless for the reason that the police themselves were on a stakeout. And the police claim they have given in evidence that they identified accused Maynard, moved from behind the truck, alongside of the truck, to the front of the truck, and disappeared. And my lords, our complaint in respect of this ground, and indeed B and C, relates to the fact.
What's B and C?
Sorry, sir, grounds B and C, which are listed just after, sir. After the ground, which is ground one, ground A, we're looking at. And you know this.
Yes, okay. Yeah.
So B and C, were submitted, also relate to the learned trial judge's treatment of the identification evidence.
But what is the specific point on ground one?
Well, my lord, the learned trial judge gave certain directions on special circumstances which we haven't quite come to as yet. But essentially, it's our position that the learned trial judge did not recognize the difference between special circumstances and circumstantial evidence. Throughout the course of the record, it's our submission that he's calling circumstantial evidence by the name special circumstances.
But surely, is there a line between the two which separates two mutually exclusive classes of evidence? Cannot circumstantial evidence provide performs the role of special circumstances?
The two are not dissimilar. But
not dissimilar, but the question is, may circumstantial evidence not constitute a special circumstances for the purpose of the act?
Yes, sir.
And here, the circumstantial evidence, which I think the judge suggested to the jury that they might treat as special circumstances, consisted of the fact that the boat, the Wild Apache, was owned by Maynard, and secondly, that of cellular phone, which was found on the seat of the truck, was lent to him according to one of the witnesses.
Yes.
Now, those pieces of evidence are circumstantial,
Yes, sir.
aren't they?
Yeah, sir.
But they are capable, are they not, of supporting the evidence of identification, are they not?
They are also capable of so supporting.
And therefore they are capable of constituting special circumstances, are they not?
They are capable of that, sir, but we would submit that they should also receive certain treatment in terms of being circumstantial evidence. That is, before they're used to support the ID, the judge should give them certain treatment and warn the jury about how to treat circumstantial evidence, rather than using it as support for the IDs of and by itself, which is what the Act would suggest you would do with special circumstances. We're saying that the learned trial judge ought to have said, these things are circumstantial evidence, and give the jury a direction on circumstantial evidence along the traditional direction about threads of a rope, for example, rather than just saying these are special circumstances which can support the ID. So that if you have doubts about the ID, support it with this, as opposed to giving a direction.
The judge did not say anywhere, as far as I can recall, that if there are two inferences and that are open to you, and they both have equal strength, and that you should not opt for the one which points to guilt.
That's correct.
But he did, in effect, say to them, look, the fact that the lorry, that there was a cellular phone said to have been lent to him on the seat of the lorry, and the fact that the boat was registered in his name, doesn't necessarily mean that he was there. Did he say that?
He does say words to that effect, sir, but...
Well, isn't that in have the same effect?
But we would, Your Honor, I would submit that it doesn't necessarily have the same effect. It seems to us that if the appellant, the jury is told in respect of the appellant that you could believe the circumstantial evidence or the special circumstances or not, it's slightly different to saying, if there's two inferences, you must draw the one that is more favorable to you. It is some help. We accept that there is some help in saying...
I don't know about saying that if there are two inferences, you must draw the one that's in favor of the accused. My understanding of the law is that if there are two inferences which are equal in terms of the strength of the inference, then you must draw the one that's in favor of the accused.
That is the phrasing I would like to adopt. So,
Well, exactly. Well,
we say that that's slightly different to saying you don't have to, because these things are found there, that doesn't necessarily mean that the man is there.
when you have that coupled with the directions on the burden and standard of proof and so on, one wonders whether the failure to use a certain formula of words is going to produce a conviction that is impeachable. Doesn't one have to look at the substance of the impression that is left with the jury?
Yes, sir. We accept that, but at the same time, we think it's slightly more than a formula. It's just not just a question of running afoul of a formula.
Yeah, but do you think the jury would be sensible enough to know that an inference that the cell phone and the boat did not necessarily mean that the man was there? Do you think that they couldn't understand that that's a favorable inference to draw in favor of the accused? I'd have thought they'd understand that was in his favor, because it would mean he wasn't there. Does the judge have to then say, well, this really is an inference in favor of the accused? I think that might be a bit insulting to the jury.
I wouldn't term it as insulting, sir. I think there's a slight we have a difficulty on our side because it's not, we see it as an absence of a clear direction on circumstantial evidence, an absence of a direction on how to treat the inferences, and then the use of what we say is circumstantial evidence to bolster the ID evidence.
But, Mr. Pilgrim, I don't know why you say that there's an absence of, in the summing up, there's an absence of anything that has to do with circumstantial evidence. I want to draw your attention to two passages. First of all, on page 520, at line 26, it just says, that simply means, Mr. Foreman and members of the jury, that the prosecution is relying upon evidence of varying circumstances relating to the offense or offenses and the accused, which they say when taken together will lead to the conclusion that the accused committed the offense. And then he goes on, circumstantial evidence can be powerful evidence, but it is important that you examine it with care and consider whether the evidence upon which the prosecution relies in proof of its case is reliable and whether it does prove guilt. Furthermore, before convicting on circumstantial evidence, you should consider whether it reveals any other circumstances which are or may be of sufficient reliability and strength to weaken or destroy the prosecution's case. And then on the following page, that's at 522, at line 4, he says, you must determine what primary facts you find and what inferences flow logically and reasonably from those facts. That is to say, they must be logical and reasonable inferences. If you find that two or more inferences can be drawn from the same facts in respect of an accused, you must draw the inference that is most favorable to the accused. The reason is that it is for the prosecution to make you feel sure of the guilt of the accused men. And if you have drawn two inferences, you must give the accused the benefit of the inference, because the prosecution will not have made you feel sure of the guilt of the accused. So, what is your complaint about that? Why isn't that sufficient?
Your Honor, because in the context of the evidence of ID, it seems to us that the general trial judge did not make any effort to make a relationship between this evidence and the ID, so that we don't know if the jury is taking this as circumstantial evidence, if they're taking it as special circumstances.
I understand the point that you are making. You're saying
didn't give directions of that kind at all.
The circumstantial evidence and the identification evidence are not, they don't fuse. They're not the same thing. And that the judge wrongly fused the two.
That's essentially the complaint.
The point is that in relation to the finding of guilt of the accused, they do fuse. They do lead to the same conclusion, because in addition to the identification issue, these bits of circumstantial evidence are helpful for the jury to determine whether or not this accused was in fact at the scene at the particular time.
Yes.
So,
yes.
So that even if technically it may not be appropriate to regard the circumstantial evidence as special circumstances in keeping with the legislation. And I say if, because as the President is pointing out, there's almost an imaginary line there. Nevertheless, the judge could not be wrong in putting those circumstances to the jury and inviting them to weigh those circumstances when they consider the guilt or innocence of the accused. So how is the accused prejudiced?
We say so that the significant point there is that rather than pointing out what is circumstantial evidence and giving them the warning to which Your Honor referred to earlier at 521 and 22, comes somewhat in a vacuum in relation to what is being referred to later on, so that the jury is open to think, well, this is not circumstantial evidence, for example. It's special circumstances, evidence to support. And we say that there may be a significant distinction there if the jury form the view that they do not have to scrutinize it in the same way that they would the circumstantial evidence. On the contrary, they use it to support rather than scrutinize first and then determine how to proceed.
I mean, you really think that the jurors are so dim-witted that they didn't recognize that the evidence of the registration of the boat and the phone was circumstantial evidence? I would have thought that, you see, Mr. I know that this is the duty of your duty to examine the summing up with a fine-tooth comb and to look for defects. But if the general instructions that are given with regard to such things as circumstantial evidence and the inferences, having once been given, have to be repeated in relation to every piece of circumstantial evidence, that would set a pattern for a summing up that would go on for days.
I understand the court's concerns.
But let me ask you something else. We're on the question of identification and the requirements of the Evidence Act. Now, those requirements, I tell you, if I am wrong, are geared towards eliminating as far as possible, as far as is practical, the possibility of a mistake.
Yes, sir.
Is that right?
That would be their focus, yes, sir.
Yes. And they are not really intended to expose cases of deliberate falsehood.
Sorry, sir?
I mean, that is something quite separate, isn't it?
Not sure.
In other words, if the person be a policeman or a civilian sets out to wrongly accuse someone and to fabricate evidence, then these are rules with regard to holding an identification parade and all of that, and the warning about the difficulty of identifying in the existing conditions. Those are not relevant to that issue, are they?
Well, Your Honor, in this case, we would say that it is. In other words, I would ask the court to consider.
Well, I don't know what this. I don't know what this is. I was asking you generally whether you agree that the rules, both are made by judges and by the Parliament, as embodied in the Evidence Act, have as their purpose eliminating the possibility of mistake rather than of exposing perjured evidence.
Your Honor, I would think they have the objective of making identification reliable as a whole. I don't know if I can say that they do not intend to prevent fraudulent behavior by witnesses.
You see, particularly in the case where the accused is known to the identifying party, identifying witness.
Yes, sir.
You know, the possibility of mistake may exist, but the reason why, for instance, in the act itself, it lists as one of the circumstances which may excuse not holding a parade is the relationship between the witness and the accused.
It does, sir.
It does suggest that, you know, that if there is, they are well known to each other, then these requirements do not apply. But that is not to say that a relative may not be lying on the accused. But that is a different matter, not one which is likely to be exposed by applying the warnings and the precautions and all of that go with the Turnbull and the Evidence Act and so on. And in this case, to come to this case, as I understand it, it was not part of the defense that the police were deliberately framing Maynard, was it?
I understood it to be that, sir.
Sorry?
I understood that to be the defense.
It was the defense that they were deliberately framing him.
Yes, so what I understood from the matter was that the defense position was that if the police saw Maynard there on the night of this incident, identified him, that why the cross-examination was along the lines of why you didn't go for him the next day.
Yes, I understand
so
that.
Well, you know where he lived. Why you didn't go to his home?
Yes.
So their position was that the police saw the circumstantial evidence, if you will, and said, well, Maynard had to be there. And
well, if that is so, holding an identification parade would have served absolutely no purpose.
In as much as it would be fraudulent in any event, sir.
Well, they knew he was, and they would pick him out easily. I mean, there wasn't any question about that. Not so?
Your Honor, there's no doubt that they would try to pick him out.
But they
Not
knew
that
him.
they tried to.
They knew him.
They picked him up at the airport.
Yeah, but sir, picking out a Rasta man traveling alone in the airport is different to picking him out, presumably, from a list of other Rasta men. In other words, if I understood the position of the defense at that time, their position was the police are down there shooting up this truck and whatever. They see various Rasta men, and then they find the circumstantial evidence, and they say, oh, that got to be Maynard. They therefore don't bother with any parade or anything else like that. They go for him. But we are submitting that just as recognition evidence can be bad, as the attempted identification of persons who you don't know, we are saying that those same police, even if they wanted to be quote unquote fraudulent, presented with 8 other dreadlocked young men, were not likely to pick out Maynard at all. Because
why not?
Because
they didn't know him for put to the police.
The witness
Just a minute, please. Was it put to either police witness that they were lying when they said that they knew him for 9 years and 4 years, respectively?
It was not said that they were lying, sir, no.
Well, was that... Well, if they weren't lying, you saying that they couldn't pick out a man who lived in an adjoining village and whom the policeman knew for 9 years, living in an adjoining village, and you suggest that he couldn't pick him out in a lineup?
So what we're saying is that one of the policemen knew him for 4 years. There's no evidence of how he knew him at all. The other police officer says, yes, he knew him for 9 years and he lived in an adjoining village. But that doesn't speak at all as to how often he sees the man. In other words, I may live in an adjoining village to people and see them not at all. I may know they live there and see them once in 9 years, maybe twice. We are saying that, like any other evidence, is entitled to be tested by an ID parade. And we are saying that the police were so influenced by what they found at the scene that they made up in their minds they were going for Maynard.
And you say that it was a lucky chance that they picked him out at the airport. They didn't really know him, but it just by a lucky fluke.
No, Malad,
they picked him out at the airport.
No, so what I would suggest there is that after they made up their minds that it was Maynard, they would have then done certain surveillance work and worked out who was Maynard, followed that person, and then at the airport did what they had to do, as opposed to what we're saying they should have done, which is to test it.
And having when should they have held the identification parade? When?
When should they have held that, sir?
Yeah, when should they have held it?
Well, we would submit so that what they should have done is that they should have tried to arrest Maynard sometime immediately after the incident.
Yes, okay. We don't know. Where was he in the meantime? Do we know?
He was in Barbados, sir.
Well, where's that evidence?
Well, sir, it wasn't contested, is what I did. I don't think it was disputed that he wasn't in Barbados.
Well, I don't want disputed. Was there any evidence to that effect?
I think the evidence was that they didn't go looking for him. They didn't go to his home.
They didn't issue a warrant.
They didn't issue a warrant. So that the question as to whether he was or was not in the jurisdiction didn't arise for them because they weren't looking for him, was the position that they did.
But it arose for him.
For Maynard, sir?
Yes, I mean, make that point more effectively, Maynard might have given some evidence or said from the dock that he was in Barbados all that time. But he never did. I am not saying that he wasn't.
I understand, sir.
But there is no evidence as to where he was.
I think that the reasonable inference from the fact that his counsel's instructions were these people didn't go for a warrant, didn't come looking for him, was that he was there.
Well, I don't agree. I would not agree with you that that is a logical inference that he was there because they didn't get a warrant for him.
Yes, sir.
I would have thought, and the fact that they didn't get a warrant for him would rather point in the opposite direction.
They assumed he was out of the jurisdiction, sir?
Well, yeah, he was picked up at the airport, was he?
Yes, but not.
Was he leaving off? Was he arriving? Leaving?
Allegation, I understood, was that he was leaving.
I see. Anyway, but so you say they should have held an identification parade when?
And sometime after his arrest.
After they picked him up at the airport.
We don't know. We don't know what was going through the minds of the police officer. Suppose they kept Maynard deliberately under surveillance and let him have full leeway in the hope that they might get leads to bigger fish. You know, we don't know. So that the fact that he wasn't arrested right away, I'm not sure that you could speculate on the basis that or that you could say that you could conclude that it suggests that the police only had the circumstantial evidence and then fabricated the identification.
I just say that in as much as that was the defense. But
Mr. Pilgrim, I understand the point that you made, which was made in the court below.
Yes.
That there was 3 months past, and they did not make any effort to arrest him, and they did not offer any explanation of that. And while my brother has suggested one, the police didn't offer it. But, that point, which I think with respect is a good point, was made by the judge at the end of his summing up when reminded of it by Mr. Tull. And I think you will agree that he put it quite forcefully to the jury. The judge did. And, so that was something which would have, might have suggested that they were fabricating the evidence of identification. But I do not, with respect at the moment, see how the holding of an identification parade on the evidence as it stands would have helped to expose the police lies. I can't see that would have served any purpose, because I think that the evidence suggests that they would have had no difficulty in picking out Maynard from any lineup. How many Rastas there may have been on it?
Your Honor, I'm somewhat fortified in that view. I mentioned this purely by way of anecdote, because this matter came before the court at a time when I was representing a co-accused who was the truck driver who pleaded guilty and got his time and whatnot.
Who is this? Another accused?
Another accused who's not even listed here. He was a fellow called Kenton Taylor, who was a truck driver. His name is mentioned in the record, but he wasn't on this trial.
I see.
He pleaded guilty, the matter was adjourned, and the others took their trial later on.
What did he get, incidentally?
My recollection says he got 12 years.
Yeah.
He died in prison about 6 weeks after.
Really?
He was a very frail and gentle chap who clearly was persuaded to join in with other bigger fish. And prison wasn't for him, sir. He didn't agree with him, and within 6 weeks he passed away. I say all that to say so that when they all appeared in the dock, that the several people assumed that an accused person, who I recall his name to be Phillips, was in fact Maynard, because the two of them were same height, similar complexion, both had beards, both had mustaches, and both had shoulder height locks, shoulder length locks, if I could call it that. So that the very real possibility of a mistake by Critchlow and Warner, we think existed.
Well, I don't know who made the mistake in court, but I don't know whether it was anyone who knew Maynard for 9 years.
So I think that the knowledge that the mistake I'm saying was made by counsel at the bar.
Well,
and we would have known him then from 1997 through to 2000, after a period of going to court every week through a PI, then coming to a number of traversals in the High Court.
Well, I don't think...
I think to being in the same environs, neighboring village. I think that type of knowledge is far better. But all of that to say, sir, that I think that the nature of the law on identity suggests that...
Well, was any of this put into evidence?
Like I mentioned that by way of anecdote.
Okay.
To say that, even with recognition evidence, there is still that possibility that people can make mistakes. And even police who are determined to be fraudulent, to use the term, sir, can make those mistakes. And I think that...
Well, determined to be fraudulent, yes.
But the council wasn't determined to be fraudulent.
Pardon me, sir?
The council were not determined to be fraudulent.
Council, sir?
Theirs was a genuine mistake.
I didn't get the words of the...
I thought you said council had mistaken one for the other.
And they weren't determined to be fraudulent.
No. Well, but if the police were, ID parade or no ID parade, I think the strong probability on the evidence is that they would have had no problem in picking out Mr. Maynard.
So we submit that the ID parade, along with the Turnbull rules, is there not only for mistakes, but to make ID reliable, and that is.
How would it work in terms of people who knew each other? How would the ID parade help?
would still have the opportunity to see that person along with others. And if you knew him as well as you thought, that you could identify him in the dark, in the context of what took place at Concept Bay, you'd have the opportunity to test that in a calm manner with 8 persons of similar appearance. And we're saying that that's quite different to saying a man who I know for 4 years, who I may have seen, I don't know how many times in that 4 years, whatever, I'm seeing him in the context of people rushing around and shooting, and I'm seeing him from the light of the truck and a street lamp, and the majority of the time he's behind the truck and at the side of the truck. We're saying
that Mr. Pilgrim is a totally different point.
I think that the 2 points can't be stripped from each other.
Well, of course it can. Because in the case of recognition, you know, the classic case of someone that you think you know well and you go up and so on, which the judges trot out every summing up. That is the case where the mistake may be made, because the mistake that was made would not be exposed by putting the man on an ID parade. You have two different aspects of the matter. What is the conditions under which you make the initial identification? And whether you know the man well or you don't know it well, that may always be an issue for the jury to determine and to be warned about. The possibility of mistake at the time when the original recognition, supposed recognition, takes place. But in the case of people who know each other well, there's not going to be any further assistance provided by holding an ID parade. Don't you agree?
Your Honor, I think I have to leave myself with this. I don't want to agree in total, because I still form the view that if a policeman says, I know you for 4 years, I'm not sure that cannot still be tested by an ID parade. Because a policeman knowing me for 4 years, into contact with
let us grant you that.
Yes, sir.
But it wasn't his evidence alone. It was the other policeman
as well
who said he knew it. Now, I take your point. Now, there is no evidence of how often he saw him and all of that. Yeah, I agree. That's probably something which should have been led. But, you know, I mean, Barbados, the villages, not such big entities. And if you are in a joining village and you know the man for 9 years, the chances, I would have thought, are very good that whether he's a Rasta and you put him with other Rastas, you're going to recognize him. Wouldn't you think so?
It's a matter of degrees, sir. I live in a small village in Bathsheba, sir. There are people in the adjoining village of St. Elizabeth that I may never see. I know they live there. I may never see them.
But then you were not a policeman, huh?
So but we contend that the judge made that mistake of saying that policemen recognize.
No, I mean not that the policeman has superior powers of observation than you.
Yes, sir.
But a policeman may take rather more interest in what is going on around than you do. I don't know, but I would.
No, we submit that there's still some utility in testing it.
Yeah. Okay.
But does Maynard say that anywhere that he knew these two officers?
Doesn't say that in his own evidence. I think it's unfortunate to some extent, sir, that we don't have the degree of this knowledge, but that is a failing for the defense.
But does he deny knowing these officers at all?
In the record, he does not deny that at all.
What you mean in the record?
In in case.
You want to give us another anecdote, Mr. Pilgrim?
No, sir, I think we've had enough of anecdotes. We've had enough of anecdotes. I think it's a case that lasted a very long time. It was around for a very long time. So, but the defense perhaps needed to explore in greater detail, if they had instructions to that effect, the quality of this knowledge, especially in the case I would think you would have attacked Warner first, because Warner said, I knew him for 4 years, but didn't say how. And Critchlow then said, I knew him for 9 years, he lives in a neighboring village.
Of course, Maynard didn't give any evidence. I mean, he made an unsworn statement.
His evidence
So that is a risk.
On the ID point.
Tell me something, Mr. Pilgrim, taking you off the beaten track.
Yes, sir.
Is it really the law that an unsworn statement from the dock must be treated as carrying the same weight as sworn testimony from the box?
Your Honor, it must be given this. I think that the statement that I recall is that it must be given the same fair treatment as other evidence in the case. I don't think.
No, but I'm asking you particularly a different question.
Yes, sir. So I think that the limitation on it is obvious to a jury, but the law states that no one must comment unfavorably on the fact that the applicant is taking that course. But I think that as the law develops, we'll reach a stage.
Well, the lawyers must. I believe the lawyers mustn't. But is there a provision which disentitles the judge from saying, well, look, in considering the quality of the strength of the identification evidence, the fact is you are also entitled to take into account that it has not been contradicted by sworn evidence from the accused. Is a judge not entitled to say that?
Your Worship, I can't think of. I mean, I beg your pardon, Your Honor. I cannot think of any statute that would prevent the judge saying that. But
I just thought that saying what he did here about giving it the same fair treatment. I thought that if I were a juror, and even if I wasn't, even as a lawyer, that seems to me to convey that it has the same weight. I don't know if this is
erroneously, sir, but in Barbados there's a great tradition of these statements from the dock.
These are hallowed words, then.
I don't know if I would call them hallowed words, but it's a.
But they're words that have been used over time traditionally.
Yes.
Well,
especially the older senior practitioners, generally speaking, it is accepted that their clients will give a statement from the dock, usually one which is brief and prepared. They're very reluctant to put their clients on the witness stand.
No, well, what I mean is the direction which the judge gave.
Yes, so that is time honored, sir.
That is time honored.
Yes, sir.
But I that it is evidence. I mean, the judge says that the unsworn statement was evidence.
That is the statement that is adopted.
But that couldn't be right, Mr. Philippine. It's not evidence. No sworn testimony was given. How could it be evidence?
I think it's described in our Evidence Act as evidence.
Really?
I don't want to misquote it. I think there's either section 21 or 24. It says that it is. I think it says that unsworn testimony is
evidence.
Could be wrong. So I think it's in the region of 21 or 24.
I am not sure whether there is a difference in the legislation as between Barbados, say England, on this. There may very well be.
I think there is. Certainly no. So I don't think that in England you can give unsworn testimony and call witnesses, for example.
And what?
And then call witnesses. In England, I don't think you can give an unsworn statement and then call witnesses to go out and swear on your behalf. whereas that can still be done certainly in Barbados.
But my impression is that the English and trial judges take a more robust approach to failure to give sworn evidence.
I may be wrong, but I think that there's definitely certainly a movement if it hasn't reached legislation to abolish them altogether.
Well, I think it's abolished in England, and it's also abolished in Trinidad and Tobago.
It's abolished here as well.
Yeah.
In St. Vincent and the Grenadines and Anguilla, I know for sure it's been abolished as well.
Barbados is holding firm so far, so for whatever reason.
But certainly in a case where the prosecution is relying on circumstantial evidence, Mr. Maynard didn't do himself any favors by the nature of his statements.
Certainly the circumstantial evidence was there to deny or to explain, and then to say something about what Warner and Critchlow were saying about him. And I think that to a lesser extent then to explore the quality of they say, we know him. Now, I can say I know various people, but what extent do you know this person in terms of being able to spot them on a dark night? But I don't think that was really explored.
He did not even give his friend from whom he had borrowed the telephone any reasonable explanation as to what had happened to the telephone, to the cell phone.
Like I said, there's no answer to the circumstantial evidence, which perhaps would have made things a little more complicated for the jury, if I could call it that. So.
Well, you say complicated, I say easy.
Depends on the quality of the explanations.
He doesn't
It
even.
may have been so overwhelming. So.
He doesn't even attack the statement that they knew him, that the officers knew him.
Those are the two things I imagine, sir, that would be fundamental to say, well, these men don't know me. They want to see me in a police station 3 years ago, or wherever he saw me 3 years ago, and Critchlow don't pass through Torps Cottage, or I never see him, I don't know him, whatever. He said he know me, I don't know him. I don't know how he could know me because I've never been in a room with him, for example, or if he knows me, know me by seeing me on the road at a distance, for example. Because this, to me, the quality of when you say you know someone from a village, have you ever been in a room with that person? Have you ever had the opportunity to observe them from, say, 10 feet? It's like, because all Rastas look alike, I wouldn't go that far, but if you're looking at a fella from 100 feet away, or when you drive through the village.
But what sort of age would Maynard have been at the time?
I think he'd have been about 26, if I recall.
26?
Young man.
Yeah, well,
20s maybe.
he would have then known him from the time he was 17.
Yes. I suppose. About that.
But
He was not a kid, he was mid-20s, somewhere in there.
But you see, the trouble going back to your separating the evidence about the phone and the registration of the boat from the identification evidence is that if you rule out the deliberate falsehood, that the police were deliberately making it up, then the importance of the circumstantial evidence is important because when linked with the evidence of identification, it produces something which would either indicate that the accused was the person seen, or would involve a remarkable coincidence, which is too improbable to accept. In other words, that the police, who are being honest, we assume, thought they saw Maynard, but they were mistaken. It wasn't Maynard. Yet, Maynard is so unlucky that it happens to be the boat with the 1,000 pounds of marijuana happens to be his boat, and the phone in the lorry happens to be a phone that was in his possession. And you say, well, no, what could be that unlucky.
Yes, sir.
That is a way in which circumstantial evidence combines with evidence of identification to strengthen and confirm it.
I think that your lordship is entirely correct that where the certain things come together in a certain way. You were submitting essentially that it could have been done in a manner, not just in terms of semantics, but in a manner that would have made it clear to the jury what their role was vis-a-vis what was found there, the circumstantial evidence, and vis-a-vis the evidence of the police.
I think that maybe I don't know. I mean, I had to be frank. I hadn't read the evidence. But the case for Maynard might have been stronger. That it was only after the police discovered the facts with regard to the phone that they then decided that the man they saw must be Maynard. So that they were not being really truthful in saying that they recognized him at that time. But I don't think that that case would have been strengthened by putting Maynard on a ID parade.
I understand, sir.
And I don't think that case would have been affected by it.
I understand, sir.
Yes, well, we have taken a lot of the time which perhaps we should have spent in listening to you, but I hope it has served.
Usefully so, I think, sir. Usefully so.
That purpose.
Pardon?
I say I hope it has served the purpose.
I imagine so. So, sir, I think that we have really discussed A, B, and C. And to a less extent D, well, D really as well. With the points that raise the ID as an issue and the circumstantial evidence is D as well.
The point in C relates to the judge confusing the jury
Yes, sir.
by introducing the distinction between identification by a civilian witness and that of a police witness. That is also covered in what you've done.
Yes, sir. So I was saying, I think we covered A, B, C, and D.
Yeah.
We discussed whether that would have had any significant effect if the recognition point in terms of the...
You see, on that point, I would, on the question of whether the jury might have been given the impression that, that the warnings they had been given did not apply to a policeman or didn't apply with the same force to a policeman. I think that perhaps may be met by a passage at page 563, line 33, where the judge is quoting from the Act. He's quoting from the Act, I think. Section 102, you see that?
Yes.
Directions to the jury. where identification evidence has been admitted. The judge then exposes that evidence which was given by Warner and Critchlow, the two police, and he interjects that. Then he goes on, the judge shall inform the jury that there is a special need for caution before accepting identification evidence and so on, and the reasons for, he goes on for the need for caution both generally and in the circumstances of the case. What I'm suggesting is that there he seems to be expressly linking the statutory constraints to the evidence of the policeman.
Yes, so I think that to some extent it would be curative of the earlier situation where he seemed to be saying that there was a slightly different approach to civilians versus police.
But I think that, I am inclined to agree with the criticism that what he said in the passage where he talked about the law being an ass.
Yes, sir.
Probably goes too far in that it might be understood to mean that it was never appropriate for a police witness to be required to pick out someone on an identification parade.
It seemed to be going too far, sir.
Yes, I think it is.
A little bit beyond what you would expect. And it seemed like the court below did not really treat that as something wrong at all. It seemed like they...
The other criticism, if I may, with respect, make of the summing up, is that the judge, with regard to this issue of identification, really recites to the jury the instructions which he is given, both by the Act and by the earlier decisions.
Like our grounds, sir, they seem it seems a bit clumsy.
Sorry?
Like the grounds that we filed, where we are saying the court below, in respect of the decision of the learned trial judge, said as follows. It's as if he is reading to the jury what he's supposed to do.
Exactly. In other words, instead of following the instructions,
and just doing what
he reads them out to the jury.
So I suppose if you were being really nitpicky, sir, you'll say he actually gave all the directions to himself and gave none to the jury. But I don't think that's...
he should not. I don't think a judge should leave it to the jury to read into the act or from the act the things which he is supposed to be telling them himself.
Of course.
These are instructions to the judge. I think he does better to follow those instructions than simply to read them out to the jury.
Point well made, sir. Sorry, sir.
Section 102 deals with the directions to the jury. And it is there that they refer to, the section refers to special circumstances. Is it in every identification that you have to find these special circumstances?
So presumably there will be circumstances in which the ID alone is sufficient. Presumably it will vary, and there will be cases in which the ID by itself can stand. Perhaps the quality of it is such, the lighting, the time,
You see, in Turnbull, it's only where the quality of the evidence is poor that they say that you don't have to direct an acquittal if there are special circumstances which might indicate otherwise that the accused was guilty, or that the accused might have been identified from other circumstantial evidence. So I was wondering whether, special circumstances, the judge here certainly doesn't say that the identification was poor. He doesn't say the quality of the identification was poor, and therefore needed to be supported by reference to special circumstances.
Perhaps it's because my understanding is that the defense for Maynard at the time would have been contending that what happened down there, and I think the judge picks it up to some extent in his summation, these circumstances would have been such a fracas and such heated circumstances, shooting, ducking, running.
A cadumant.
Like a cadumant, if you will. The old word used to be a tadumant, my mother reminds me. But it's now become a cadumant, which the older people cannot understand. It came from a big to-do.
Yes.
And it's corrupted now into this cadumant. So, but these circumstances, I think the defense was saying, so much is going on down there. There's so much shooting, there's running, ducking. Police are under fire themselves. That the quality of the ID was poor. I think that was their contention. And that therefore, in the circumstances that the ID had to be poor, the judge would have needed to treat it.
What I didn't understand is how the headlights of the vehicle could have assisted in identifying the man before he reached in front of the vehicle.
I thought that was glaringly obvious that the headlights, based on what they were saying, the headlights would have been virtually no help to them.
It would have been a hindrance, I would have thought.
I thought it would be. Concept Base is a very rugged area, and hindsight is 2020, but I think that the circumstances are such that a visit to the locus would have helped the defense in terms of showing how dark potentially the area was in terms of the absence of lighting. There's a reference to a street light, but at that time in 1997 there was no street. So I imagine that there was some light off of some building, but there's certainly, until there was, more recently there's been a big fish market and a lot of facilities have been placed there and are very old, but at that time there was virtually nothing there.
But I'm surprised there was no request for her to visit the locals.
It seems there was none.
Well, it's maybe everyone connected with the case knew it so well, and they didn't think it necessary.
I think that's part of it. So the other part is that in the three-year interim between 97 and 2000, there were definite improvements to the area. There were the fishermen there had been complaining for decades about the fact that they had a jetty that was dropping off, and so the government had done various things for them, which made the area somewhat. I think even
how far of the East Coast is God sent me?
I don't know if Your Honor is familiar with Bathsheba.
Yeah.
South of Bathsheba.
It would be south of Bathsheba.
Oh.
About, you would have Bathsheba, you would have Martins Bay, a place called College Savannah, and then Concept. But in miles, I'm not sure. Probably about 5 miles, 6 miles down the coast. Very similar in terms of its appearance, large rocks and cliffs and whatnot. But there's this one jetty where the fishermen were landing at the time, but since then it's been refurbished a great deal. But in 97 there would have been this one very fragile, broken down jetty with some boards dropping off of it and no facilities for processing fish and so on. So there was, between 97 and 2000, I believe that much of that came in. So I suppose that council would have said that to go there now, it looks so much better and brighter now with all these buildings and lights, that to go there now would be unhelpful. So I think they may have been hamstrung to some extent by that. But again, I think it's mostly anecdotal, sir. I don't think this helps the court.
Anything further, Mr. Pilgrim?
Only if your lordships wish specially to hear me on any particular matter, sir.
On?
On any particular matter you may wish to hear me on.
No, I don't think so. No question. Anything?
But you would say that the judge did warn the jury sufficiently about the special need for caution in approaching the ID evidence. And he did point out to them that that ID evidence came from Critchlow and Warner in respect to Maynard.
Yes, he did.
Yes. Are you saying anything about the sentence being excessive? Sentence.
Your Honor, to some extent, I may have misunderstood my duties here today in general, and I think that I was not prepared to go as far as that, certainly.
Yeah, okay.
But the sentence,
Maybe I'll supply leave.
sorry, sir.
Yeah. Okay, well, you need to tell.
What I could say about that is this, that the court might want to consider the fact that Mr. Maynard has had a rather difficult time in terms of the amount of time this matter has had to be processed, and that during that period his mind has not been at rest in terms of whether he was serving time, not serving time, and the delay therefore may have caused him some considerable grief, which this court could look into. But in as much as he's been before the court from 97 to today's date without any real resolution to the matter, the court may take that into consideration.
Has he been in custody since 97?
No, sir. He was in custody from 97 for a period of months, and I can't give an exact, like I said, as I have to admit, I didn't expect to be necessarily called on to this extent. But he was incarcerated then for a period of months, and then from 2000 till today.
I think the Court of Appeal ordered the sentence to run 6 weeks. Was it 6 weeks
After the date of the
after the date of the hearing? Huh?
I'm not exactly sure of the reason, but in Barbados, generally, once you appeal, you lose 6 weeks. Or rather, you gain 6 weeks, depending on how you look at it. In other words, for filing an appeal, it is something that I'm not certain from whence this tradition has come. I'm sure it's right for challenge.
The hearing was in the Court of Appeal was on, what was the date?
It was the
8th of November 2001.
Yes, in the Court of Appeals.
And was it not to run from 6 weeks after that date?
Yes.
I think it was 6 weeks after the
6 weeks from December the 15th.
2000, which was when he was sentenced.
Yeah, from the 6 weeks is from the date of sentence.
From the date of sentence.
Well, okay. Well, that's so that's even better from his point of view. Yeah. So I think that as is, apart from the uncertainty as to his fate, I don't think he will have been prejudiced by the delay.
Well, sir, no. He's been in the same place.
Beg your pardon?
He's been in the same place throughout. There's been no significant change of his circumstances. It's just the delay in itself, not being able to know what you're doing, so to speak.
Yeah, well, he is the time that he has spent in prison from 6 weeks after being sentenced on the 15th of December 2000 will will count against his sentence, so that he will have served by now virtually 6 years, nearly 6 years.
Yes. I'm sure the court understands that you are given an extra 6 weeks, though.
Beg your pardon?
The court understands that you're given an extra 6 weeks for appealing. Because you don't lose 6 weeks. You start serving your sentence from 6 weeks later.
Yes.
Is there a statutory provision for that? Do you know?
My lords, I honestly can't recall. I believe there must be something in the ballot.
But there has been no challenge to that, so that we will leave that touched anyway.
Yes, sir.
Yes. Very well. Well, thank you, Mr. Pilgrim.
Grateful to the court.
We need to retire. We need to retire. Let's try this season in brief. This is an application. Yes, you may take a seat. Thank you, Mr. Pilgrim. This is an application for special leave to appeal against the conviction of the appellant on two counts. One of importing marijuana into Barbados, and the other of trafficking in marijuana. The quantity of marijuana involved was considerable, over 1,000 pounds. And the charges arose out of an incident at Concept Bay in the early hours of the morning of the 20th of May 1997. The police had a stakeout at that bay when at about 4:15 a.m. in the morning, a boat came in from the sea to a jetty where a truck was waiting, and a large quantity of bales of marijuana were offloaded from the boat and placed on the truck. When the truck was about to drive away, the police made their presence known, called on the people involved to remain where they were, announcing that they were police. The response was a fusillade from the guns that were being carried by some of the party involved in the exercise of transporting the marijuana. Police answered fire. One of those who were involved in the criminal activity was killed. But the appellant was identified by two policemen who were involved in the stakeout. But he was not captured at the scene, but he escaped and was only arrested some 3 months later when he was picked up at the Granby Adams International Airport by the same two policemen who identified him. They were Sergeant Warner and Cunningham.
Critchlow.
And this is Sergeant. and Sergeant Critchlow. Their evidence was that they knew the appellant Maynard for 4 years and 9 years respectively. In the case of Critchlow, he lived in an adjoining village to Maynard. The other evidence against Maynard consisted of the following. The boat, Wild Apache, from which the marijuana had obviously been offloaded, was registered in the name of Maynard as owner. And B, a cellular phone which was found on the front seat of the truck on which the marijuana was loaded had, according to the evidence of a witness, Ricardo John, been lent by him to Maynard. There were originally three counts to the indictment. Which was made against the appellant, and there were a number of other persons who were charged with him with the similar offenses. The third offense was possession of the marijuana, but the conviction for that offense was set aside by the Court of Appeal, which held that it was impermissible to convict of that offense, as well as the offenses, the other two offenses of importing and trafficking, which implied possession. And the Court of Appeal referred in this connection to the relevant provision in the Interpretation Act. The Court of Appeal upheld the convictions, which were by a majority of 7-2, and ordered that the sentences of 25 years on each of the two for each of the two offenses, which convictions for which survived, should of 25 years each should run from the 6 weeks after the 15th of December 2000. Regrettably, that while the appeal was heard with commendable promptness on the 8th of November 2001, judgment was not delivered by the Court of Appeal until the 17th of November 2005. There were a number of grounds of appeal that were advanced as justifying leave, special leave to appeal. These grounds were centered very largely on the directions that were given by the learned trial judge with regard to the issue of identification. It was submitted that the learned trial judge had not properly directed on what evidence could amount to special circumstances, quote unquote, within the meaning of the section 100 of the Evidence Act.
102, I think. Just 102. 102.
102, that should be. It was another ground was that the judge failed to direct the jury to exclude from the deliberation on special circumstances evidence which gave rise to inferences that were equally consistent both with the defendant's innocence, the appellant's innocence, and as well as his guilt. The ground was that the judge had confused the jury by suggesting that that there was a distinction between identification evidence given by a policeman and that given by a civilian witness. In relation to the interpretation and application of the provisions of the Evidence Act, was also submitted that pleaded that there was no proper direction given on circumstantial evidence. And the ground which was not pursued in oral argument, that the judge failed to put the defendant's case to the jury before they retired. We find that there is no substance in any of these grounds. There does not appear to us to be an arguable case in relation to any of them. The summing up of the judge was by no means perfect. There are criticisms that may be made of his summing up. But none of them, in our view, can arguably be suggested to constitute a material misdirection. The judge gave very full directions with regard to identification evidence, and certainly in substance, they contained all the warnings that are required both at common law and by the Evidence Act. We do not accept that there is a distinction, as argued by counsel, between circumstantial evidence unquote, special circumstances, unquote, within the meaning of the Evidence Act. That is not to say that these terms are synonymous, but it is perfectly impossible for circumstantial evidence to constitute also special circumstances for the purposes of the Act. The criticisms of counsel in this case centered on the failure to conduct an identification parade. But we do not think that in the circumstances of this case, it was necessary for an identification parade to be held in order to for the evidence of identification to have been admitted. So far as the provisions of the Evidence Act are concerned, they do not require such a parade to be held if it is not reasonable to hold one, or if there are special circumstances which support the identification. In this case, given the fact that given the evidence that the appellant was known to both policemen for a considerable period of time, and given the fact that he was identified by them at the airport, apparently without difficulty, we do not consider that it was. We do not consider that it was reasonable for an identification parade to be held, as there is every indication that both policemen would have had no difficulty in picking him out on such a parade. The challenge of their identification would not have been assisted by the holding of an identification parade. Furthermore, we consider that the evidence with regard to the registration of the registration of the boat, and the presence of the cellular phone in the front seat of the truck, where special circumstances, in the sense that they tended to support the identification because of the improbability that these circumstances which pointed towards the appellant would have been compounded, in a sense, by a mistaken identification or recognition on the morning in question by both policemen. With regard to that, we also hold that the judge's evidence with regard to the judge's direction with regard to the inferences that might be drawn from both these pieces of circumstantial evidence was quite proper. He did indicate that both in his general instructions that when two inferences were capable of being drawn, that the one which pointed to the innocence of the accused should be preferred by the jury to the one which pointed to his guilt. And in relation to the specific evidence, the two pieces of circumstantial evidence to which I have referred, the judge did instruct the jury to ask themselves whether they necessarily indicated whether they necessarily led to the conclusion that the appellant was at the scene at Concept Bay at the relevant time, and suggested that they might not lead to that conclusion. For all these reasons, we do not consider that this is a proper case in which special leave to appeal should be granted, because, put simply, we find that there is no arguable case that there has been a miscarriage of justice as a result of any misdirection or the omission of any direction by the trial judge. Accordingly, the application is dismissed, and the sentences which were confirmed by the Court of Appeal are also confirmed by us and are to run as from the date which the Court of Appeal specified, that is from 6 weeks after the date on which they were imposed, namely the 15th of December 2000.